Good morning, everyone. Welcome. Thank you for joining me today. My name is Mike Russo, and I am the owner of WorkBright. I'm an occupational hygienist. I'm also an occupational health and safety consultant. I work with organizations to help them better understand risk and ways to control it effectively to protect workers from harm. About 6 months ago in November, we held a webinar just like this, 30 minutes, action-packed, and we covered some very important changes to the Occupational Health and Safety Act in Ontario. And many of those changes have come into force. And I was very lucky to be joined by Luiza Vikhnovich, who's a friend and a lawyer with Sherrard Kuzz, to provide some insight as to what those changes meant for employers. Fast forward 6 months, here we are today, and we're covering a very different topic, still in the field of health and safety, but also timely. It's Safety and Health Week this week, and many of your organizations are having functions to celebrate and to remind everyone about the importance of health and safety in the workplace. So we felt that this was a timely event, and we wanted to host an event to cover 3 legal lessons in health and safety that every employer in Ontario should know, even if you are in HR and health and safety. What we're going to talk about today is very important. I'm going to, apologize in advance. This is 30 minutes. This is action-packed. We're going to move very fast through 3 important lessons, and Luiza is going to share some findings from decisions made from court cases in 2024 that are of relevance to workplaces all across Ontario and even in Canada. So Luiza, thank you for joining me again today, and I'm going to pass it over to you to share a little bit about your background and who you are.
Yeah, Mike, thank you so much for having me back. It's a pleasure to be here, especially given the timing of this topic and the week. For those of you who I haven't had a chance to introduce myself to previously, so my name is Luiza. As Mike mentioned, I'm a lawyer with Sherrard Kuzz. My practice is in labor and employment across the board, but I do have a particular niche in health and safety matters, and I'm involved with everything from proactive intervention to defending against ministry prosecutions. That's me in a nutshell.
Awesome. Yeah, and I will include Luiza's bio in a follow-up email after this webinar, and I encourage you to reach out. Very talented, and so I do encourage you to reach out. We're going to cover 3 lessons that are very important, and so maybe Luiza, you could share with us very high level what those 3 lessons are, and then we'll go deeper into each one by one.
Sounds great. So as you know, Mike, in the world of occupational health and safety, there have been so many developments that we are really spoiled for choice when it comes to the kinds of topics we can talk about. I think you and I have done a good job of kind of streamlining and focusing on 3 key areas that we want to focus on today. And so folks, the first one that we'll be covering is a decision that comes out of the Court of Appeal for Ontario. It's a case involving a local Dairy Queen franchise and a critical injury that happened, and the prosecution of that critical injury and the offenses under the Act as a result of that critical injury. And we're going to be taking a look at some key legal takeaways from that decision, as well as operational practices, things that could have been done differently and what to watch out for. Then we're going to be taking a look at the very infamous developments in the RV Sudbury saga, which has been keeping us quite busy for the last 2 years. There have been so many decisions that have been released in that particular case. We're going to be focusing our discussion today just on the most recent development in that case, and centering our discussion today about due diligence. Essentially, what can you take away? What can your organization take away going forward? Is the law settled on due diligence? What are practical takeaways that we can look towards? And then lastly, we're going to be looking at criminal liability. Because the focus is so much on provincial offenses, we often forget that sometimes these same incidents can actually ground criminal liability as well. So we're going to be taking a look at what the differences are between provincial and criminal offenses, and how those cases can play out.
Wow. Okay. Lots to cover in 25 minutes now. Sorry. So let's just a piece of housekeeping. If you do have questions, we're going to do our best to get the questions at the end of this webinar. We've reserved 5 minutes. Please enter them into the chat, and we'll do our best. If we can't get to them, I will follow up through email. And the other piece of information I wanted to share is following this webinar, probably tomorrow, you'll receive an email from me with a couple of important details. One is a survey. It's a very brief survey, 1 minute. It'd be extremely helpful to me if you can complete it and just share some feedback and some of your insight as to what your experience was. And I will also share a link to the recording of this webinar that will be posted on my website. Feel free to pass it along and share with your colleagues. So let's get on with this. Lesson number 1. I'm going to read this verbatim because there's a lot to take in here. So lesson number 1 is to structure your organization carefully and ensure measures are in place to protect workers. This particular case, we talked about it before, is quite significant, given the time of year with a lot of younger workers entering the workforce, summer jobs, co-op students. This case covers a lot. And so maybe I'll pass it over to you to share a little bit about what happened and what it means for employers.
Absolutely. So let's start first with what happened. This case involved a teenage worker who was working a summer job at a local Dairy Queen. And in the process of kind of one of her shifts, she was operating a blizzard machine. The blizzard machine did not have a plastic guard on it at the time that she was operating it, although one was allegedly there. It just wasn't being used at the time. Unfortunately, her hair became caught in the spindle of the machine, and she suffered really egregious spinal injuries as a result of that when her hair became caught. So the franchise, which was a numbered company, was found guilty under the Occupational Health and Safety Act for essentially failing to ensure that there was a guard on the machine. It turns out that apparently the plastic guard had been removed by one of the team leads, who basically had said, during rush periods, it helps cut down on time when processing orders. And so ultimately, this goes to a prosecution in the lower courts. The lower courts impose a fine of $7,500 onto the company, and the Crown actually appeals that fine amount. So the court finds that there is guilt, but the fine amount is what the Crown was disputing, not the fact that there was guilt. This goes up to the Court of Appeal, and the Court of Appeal for Ontario increases the fine from $7,500 to $40,000. Okay, and that has to do with a number of factors, but I think from a legal perspective, there's really two kind of key takeaways in the court's commentary that we can all kind of learn from. The first takeaway was that the Court of Appeal found the lower court had made a mistake in considering comparators of fines imposed on individuals when this was actually a corporation. So that was one of the things that was taken into account and why there was a lower fine amount imposed at the beginning. The second key issue, and one that I think is really important to emphasize, is that the court at the time, the lower court, didn't actually consider the full scope of economic activity of the corporation. It turns out that this franchise owner actually owned 8 franchise locations in total. And at the time that the sentence was imposed originally, that $7,500 fine, they had only considered the scope of activity to be limited to one location where the incident had actually happened. So when the court took into consideration the total number of workers that were employed by this corporation, that was the justification for an increased fine amount. And I think that that's a pretty significant outcome and a reminder from the courts about what corporate structuring looks like and how that might impact fine amounts in the event that a corporation is found guilty under the Act.
That's interesting. So really looking at, the full scope of operations as opposed to that one in particular store, and that's essentially the outcome. Interesting because also, from a safety perspective, we have a young worker here, and when we look at that particular situation, there's a lot of research to suggest that new workers and young workers, many young workers are new workers, have a higher risk of a lost time injury in the first month on the job, sometimes about 3 times as high, 4 times as high, and that's local research. A lot of organizations that bring in new workers or younger workers in particular really need to consider, what does the onboarding process look like? What does the orientation process look like? Are we ensuring they are aware of the hazards in the workplace? And when I read this case and we discussed it previously, a lot of these alarm bells came up. And so can you maybe speak to that as to maybe what some practical initiatives employers can take?
Absolutely. So, I mean, in this particular case, it's interesting because the franchise owner, in trying to establish the defense of due diligence, pointed to the fact that there is actually a company handbook that talked about what the procedures are and how to properly ensure that a machine is guarded. But interestingly, there was no evidence to show that the employee had actually received training in the handbook or that the employee had even been provided with a copy of the handbook.
Mhm.
So I think to your point about onboarding, absolutely, we want to make sure that the things that are on paper, we have those things in place and we've thought through the procedures associated with really any hazard in the workplace. But the biggest thing is, particularly in any industry where retention is kind of an ongoing problem, or you do have seasonal workers kind of coming in and out, really making sure that it's not just in writing, but in practice as well, right? And through the work of, consultants like yourself being brought in and kind of just making sure there's no gaps in the way things are being applied, those are the key areas for corporations to focus and hone in on, in my opinion.
Yeah, and that's a really good point. And just to add to that, one thing that I've often seen is for workplaces that have done a great job of building extensive orientation programs that take into consideration health and safety, oftentimes the supervisors who are supervising those new workers are not necessarily made aware of the situation and the risk, and there's certain steps that can be taken to really prepare supervisors, because I personally believe that ensuring that supervisors are prepared when bringing in new workers is just as important as providing information to the new worker themselves. So great, excellent. So let's move on. We're tight for time, but that's lesson number one. Just another reminder, if you do have questions, please put them into the question and answer box, and we'll do our best to get to them at the very end. So lesson number two, let's move on. This is an interesting one. Many people on the call here on the webinar probably are familiar with this case, and if you're not, then Luiza will provide a bit of an overview as to what happened. But essentially, lesson number two is to know your role in the owner-contractor relationship. And there's probably a lot of lessons here. That's just maybe one. But maybe you can share a little bit about what happened with the City of Sudbury case.
Yeah. So as a quick recap, because I'm sure many of you are familiar with this decision, this case arose from a pretty tragic incident that happened on a construction project a number of years ago. The City of Sudbury owned the construction project and contracted with a general contractor to do water main repair work and to repave roads. That's just part of the municipality's obligations to maintain kind of a good state of repair. And a pedestrian was walking through the construction project, or just adjacent to it, when one of the GC's employees was operating a road grader in reverse, and fatally injured the pedestrian when she was struck by the road grader. So those are the facts that then spiraled into what has been, like I mentioned earlier, 2 years worth of litigation, with decisions going as high as the Supreme Court of Canada. I won't get into all the nuances and the legalese of kind of, everything that has happened, but suffice to say, there's really kind of two key issues that arose out of this case. The first issue, which we are not going to be focusing on today, but I will briefly summarize, is an issue that came up when the city was charged as an employer. And specifically, that I think jarred a lot of folks, simply because, the city was quite clearly conceding that it was an owner of the construction project, but it, at first blush, wasn't really assuming any responsibility over the workers that were performing the construction work on the site. And so understandably, that caused quite a bit of heartburn for a number of people and industries when it comes to, can an owner be charged as an employer? And, to kind of cut to the chase here, the current state of the law in Ontario and the outcome on that is, yes, an owner of a construction project can be charged as an employer. So that is the outcome on the first issue. The second issue, and the one that we're focusing on today, and I think we can have a really productive conversation about, is the issue of due diligence. There was a question of, okay, if the city, can properly be charged as an employer, was it duly diligent in preventing the accident that occurred that day? And the lower courts actually found that as an employer, the city was duly diligent and in taking steps to prevent the accident for a number of reasons. And we thought this was settled until the Crown decided to apply to the Court of Appeal for leave to appeal the lower court's decision. And just a couple months ago, we got what we think is our last decision, hopefully in this series. And the Court of Appeal denied leave to appeal and confirmed the lower court's decision. So we basically now have kind of a solid footing, I would say, on what due diligence looks like, what are the factors we should consider in a due diligence defense. And importantly, the Court of Appeal's last and final commentary on this, which is that general acts of due diligence aren't sufficient to make out that defense. There has to actually be specific acts that are taken. So what I mean by that is, there has to be something that is tailored to the particular incident and what contributed to that incident. So in this particular case, there was evidence that the city had received complaints from the public about the lack of signage and the crosswalks that were available for pedestrians. And there was evidence that the city had actually gone to the GC and raised these issues and asked the GC to fix these issues. That's an example of a specific act that was taken to demonstrate an avoidance of this particular incident. And that's something that the Court of Appeal said, yep, that's on the evidentiary record, and that clearly exonerates and demonstrates why the city was duly diligent. So that's where it is in a nutshell.
You've just summarized, was it 3-4 years of mistakes in 10 minutes, yeah. Which is great. But, very important, because I think, there might be people on the call here that are not operating at the scale of a municipality, perhaps, or bringing, like, as an owner and bringing in contractors. But I think there's some important lessons for those who might even be hiring a contractor to perform a renovation in a bathroom office, or office of a bathroom, and really bringing those, carefully considering who you're bringing in to do the work, and not only basing it on price, but looking at some of the other factors that perhaps the Supreme Court laid out, so that you could demonstrate due diligence, asking about what training their employees have had, because typically it's, do you have WSIB coverage, and that's it. But there's a lot more that can be done to really ensure that you're bringing in a contractor or even service provider that really, prioritizes health and safety, because there are implications for the owner. I mean, you've seen on the news, or your company name gets plastered all over the media when there's an incident, regardless of, where it happens. So looking at some of those initiatives could potentially help, regardless of the size of the project.
Yeah, and it might be actually helpful just to kind of quickly unpack what some of those considerations were from the Supreme Court of Canada and what they laid out. Because to your point, I think those are broadly applicable across industries, right? And regardless really of the context of this particular case. So the Supreme Court of Canada listed a few different things that they said are indicative of due diligence. They said it's a non-exhaustive list, so it doesn't mean that these are the only things that can be considered. But the first key consideration is the degree of control over the workplace or the workers there, right? So in this particular case, as you can imagine, right, the city was saying, this is the whole point why we delegated the work to a GC on site. We didn't have control over the workers. There was evidence that in the contract, for example, they had the ability to discipline the workers, but there was no evidence that the city had actually ever done that. So that's an example, right? So how much control do you as an entity have over the workers that are performing the work? And whether the whole point of delegating the work to another entity was taken into account at the very beginning. Was it clearly outlined who would be responsible for what in an attempt for you as an entity to try to overcome a lack of skill or a knowledge or an expertise to complete that project? Another factor that the Supreme Court of Canada laid out is whether steps were taken to evaluate the contractor's ability and to ensure that they're complying with the regulations, right? So you mentioned the WSIB compliance, right? That's a kind of quick way to double check, on the front end, do they have their paperwork in place? But, particularly in this case, I think what was helpful was the city had an ongoing relationship with the GC for about, I think, 40 some projects. So, there was clearly that demonstration of they've been working together for a long time and considering what checks and balances the GC had in place, right? So just thinking about if you are in that contractor relationship and that business relationship has been ongoing for a long time, that's something that's probably more reliable when it comes to working together again in the future, and potentially evidence of due diligence there as well. The last factor that I'll just quickly highlight is whether the constructor's work was monitored and supervised to ensure that essentially things were being done according to the book. And we have to be careful there, because if you do too much supervision and too much monitoring, you're starting to step into the shoes of potentially being an employer. So I appreciate that it's a bit of a catch-22. But I think in this particular case, and just a way of seeing it, the city, when it became aware of issues, delegated those issues back to the GC for them to address. And that was considered to be enough relative to the city's position in that project. So that is a quick example of some of the factors of due diligence and how we can apply them to other contexts as well.
Excellent. Yeah, and that's very important. And just for those of you on the webinar, I will be including an article that Luiza wrote in the with the recording. I encourage you to review it. It lays out those points of due diligence that I think are very important, regardless of the size of company you are. So we have about 9 minutes left. We have one more lesson to cover. We're going to move on. And just a reminder, if you have questions, please enter them into the chat. And I will be following up with an email, including a survey and a recording. If you could please complete the survey, that'd be much appreciated. So let's move on to lesson number 3. This is an interesting one because it really shifts everyone's attention from provincial offenses to criminal code now. So, and I'm not an expert, I'm not a lawyer, so I'm really interested to hear what you have to say. But lesson number 3 is to ensure that supervisors and managers understand their legal health and safety duties and that they take action to prevent harm to workers. Interestingly enough, so maybe first you can just kind of decipher the difference between, a charge under the Occupational Health and Safety Act versus criminal code.
Yeah, so under the Occupational Health and Safety Act, an offense is a strict liability offense. So what that really means is that the Crown just needs to establish the act. Once the Crown has established the act, it's then on to the accused or the defendant to make out a defense of due diligence, meaning they did everything they could to prevent the act from happening. Intention isn't really a part of that analysis. So if we think back just a second ago to that Dairy Queen case, the fact that the guard was removed because it was rush hour and they were trying to put out more orders, that intention does not really matter. It's simply, was the guard there? No? Okay, offense is made out, in which case we have to demonstrate why we did everything we could to make sure that guard was there. Now, in criminal charges, and particularly criminal negligence involving bodily harm or death, which is what we're focusing on today, we need that intent element, which isn't present in occupational health and safety offenses. And intent doesn't necessarily need to be deliberate or willful. There needs to be what is essentially a wanton and reckless disregard for the health and safety and lives of others that are under an entity or a supervisor's direction and control. So that's at a very high level the distinction between the two types of charges.
Interesting. And so in 2024, there were actually a couple of cases that were criminal charges against supervisors. Maybe you can elaborate on the one that occurred in Ontario.
Yeah, so most recently, the one that's happened in Ontario is a case called RV Argyles. And we actually just got to the decision finding guilt. So the supervisor was charged with criminal negligence causing death, happened last year. But just recently, we found out there was a sentence imposed on the supervisor of 5 years jail time.
Wow.
Right. And so we can also talk about the difference later on in terms of penalties under criminal versus provincial schemes. But let me just give you a quick kind of rundown of what actually happened in this decision so we can really, understand why the outcome. This was a case involving an employee who had just been on the job for about a week and who was operating a dump truck. The employee had concerns about the truck that he was operating, and he'd actually texted his supervisor expressing those concerns. He said, there's issues with the steering, something felt off about the way that the truck drove. The supervisor chose to do nothing with that information and instead sent him out to do more work. Quite tragically, while he was driving the truck, the left tire exploded. The front left tire exploded, and he veered off the road, struck a tree, and ended up into a ditch. He died immediately on impact. So this decision, as you can understand, was, again, just based on the events and what happened, quite significant, because particularly in kind of considering expert evidence that was led at trial, it was found that the tires on the truck were so obviously bald, and so contrary to kind of other types of legislation like the Highway Traffic Act, et cetera, that it was unreasonable, essentially, for any supervisor to have allowed their worker to operate a truck under those conditions. And so, again, when we're talking about criminal liability, for these same kinds of incidents, we're really talking about what is a marked and substantial departure from the reasonable conduct of a supervisor in those circumstances. So there was so much evidence demonstrating a worker raising concerns and the supervisor essentially ignoring them, that there was just kind of an overwhelming amount of evidence supporting that this really did meet that threshold and that level.
Interesting. So we're dealing with up to 12 months jail under the Act, whereas under the criminal code, if it's a criminal charge, is the sky the limit? What's the
Yeah, so it could be imprisonment for life as kind of the top end of that. When there's specifically a fatality involved, if there's bodily harm, it's 10 years, I believe. But the key distinction there too is not just that, it's also under the Occupational Health and Safety Act, there's a potential for a fine for individuals. So anyone who's not a director or an officer of 500,000 as a maximum, and or jail time of up to 1 year, right? So that's important for us to consider there as well, as compared to, again, when criminal liability is involved, we could be looking at significantly larger jail sentences, to your point.
So we have a minute left before we open up questions, but just based on your observations and your expertise in the field, what are you seeing in terms of frequency trends when it comes to charges under the Act versus charges under the criminal code?
Yeah, so what I'm seeing as a trend generally on the criminal side of things is that the sentences that are being imposed are increasing basically every single time. The last decision in RV King, which was a criminal liability case involving a wastewater treatment facility in New Brunswick, that decision resulted in a 3-year sentence for a supervisor after a young worker had drowned in the system with the supervisor's knowledge, and that was a whole other case that I won't get into right now, but just to show you, we are seeing increases every time a criminal case is coming up in the amount of jail sentence that's imposed. But that being said, they are still happening less frequently than we see supervisors being charged under the Occupational Health and Safety Act. Those charges are far more frequent because, frankly, we're looking at a different level, right? We're not looking at that wanton and reckless disregard or conduct that is just so egregious and off the charts. We're looking at something that's a little bit slightly less, perhaps not meeting the mark of competency, which is a requirement under the Act. And so we are seeing that coming up more frequently.
Yeah, and very important. And I think, another underlying theme here from a health and safety perspective is ensuring that supervisors and managers understand their duties under the Occupational Health and Safety Act, for leading teams of people, which is really important. There's quite a few under the Act, but I think there's possibly some, they're transferable over to the criminal side as well. But we often talk about, understanding hazards and risks, instructing workers of those hazards and risk, and documenting, that has been done. So excellent. That brings us to the very near end. So 3 lessons we covered. Just a reminder, if you have any question, please put them into the chat or the Q&A. We do have a question now. I'm going to open up the Q&A session. We have one question here. Are specific departments in an institution responsible for managing their projects? For example, facilities hire contractors for a plumbing project, or should it be managed and monitored by the institution's health and safety department? So that's a very unique, very specific circumstance, perhaps, but I think it really, I don't know if you have any insight on that, Luiza, maybe what might be the best approach or possible approaches to consider.
I mean, we really have to consider, I think, that question from the angle of who would be essentially in the line of fire in a prosecution, right? We would probably be looking at, the municipality as a whole and whether the municipality as a whole was liable, right? And so we'd really be looking at evidence of due diligence across the board. And I think from that perspective, any evidence that could be adduced, including whether it's specific to the steps taken by a particular department or whether the health and safety team was involved in kind of assisting with that analysis, all of that evidence would be particularly helpful for a due diligence defense. I don't know that there would necessarily be a distinction between the departments, but I'm going to give the typical lawyerly answer of it depends on the circumstances, right? What happened and what contributed to the charges.
Yeah, good point. I do think it is very specific, but it is a question that does come up occasionally, and I think oftentimes it also depends on the organizational structure and how it manages its day-to-day operations. Just last opportunity for any questions. Here's another question that has come in. What would be the duration of retention of health and safety documents after a project completion? So I guess when a construction project is complete, is there a general period of time after which documents should be retained and perhaps discarded after a period of time?
Yeah, so I think maybe the answer to that lies in the limitation period under the Occupational Health and Safety Act. So in terms of, when charges can be laid up to 2 years after the date of an incident. And so, if it becomes a question of, whether something was done in compliance on a construction project, after the fact, I think we'd be looking realistically at a 2-year period of when there could be potential liability arising out of that. So I would say at minimum, 2 years should be the retention period for any documents post-project. There may be other factors that contribute to wanting to retain those documents for longer than that, quite frankly, but I would say minimum 2 years.
Great, good. And just like that, 30 minutes is up. So thank you again, Luiza. This was an excellent conversation. I learned a lot, and I was, it didn't disappoint, that's for sure. We will be following up with a recording. You will get an email from me. As I mentioned, it would be extremely helpful if you can complete the survey that's included in that email, and I will include a recording of this webinar, as well as some articles that Luiza has written that expand on some of the lessons that we discussed today. Luiza, thank you very much again for joining me. I look forward to possibly doing this again in the future, and everyone else who joined, thank you very much.
Anytime, Mike. Thanks again.
Take care.
Take care.